this presentation, we'll talk about constitutional law. When the Constitution was first written, one of the primary functions was to organize this new central government. The question was, how much power should we give to the federal government, and how much power should we give to the states? The Constitution says that certain tasks are specifically reserved for the federal government to handle. They are levy taxes, declare war, raise armies, and regulate interstate and foreign commerce. Everything else was given to the states. Also included in the Constitution is what we know as the preemption doctrine, which is the power to prevent the states from passing laws which conflict with federal laws. Sometimes this means prohibiting states from passing any laws on a particular subject. In addition to defining the relationship between the national government and the state governments, the Constitution also specifies the relationship between the states. Article 4, Section 1 states that full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. For example, if someone wins a judgment in Maine, it should be enforceable against a person who has moved to Connecticut. So, where would that put the subject of same-sex marriage? Can states have laws limiting marriages to only those between heterosexual couples? And can those states be forced to recognize the legal relationship of a same-sex marriage formed in another state? Under the full faith and credit clause, it would appear that states would have to accept same-sex couples. But there is an exception to full faith and credit, and that's when it goes against the public policy of the state. So on the basis of this exception to full faith and credit, it would seem that a state which specifically rejected same-sex marriages might be able to refuse one from another state. Constitutional law covers some of the most controversial topics in our country today, and this is one of them. In an earlier module, you learned that the federal government's powers are divided into three branches: legislative, executive, and judicial. Since the Constitution went into effect in 1789, 27 amendments have been added. The first 10 amendments were added almost immediately, and they're called the Bill of Rights. These amendments protect individual rights from government overreaching. They include such items as freedom of speech, freedom of the press, freedom of religion, the privilege against self-incrimination, the right to an attorney, the right to a trial by jury, protections against unreasonable searches and seizures, and the prohibition against cruel and unusual punishment. Freedom of expression is used to describe rights found in the First Amendment, and freedom of speech is one of them. There are really 5 types of freedom of speech cases that the Supreme Court has been asked to rule on over the years since the First Amendment was passed. Decisions from the Supreme Court have differentiated according to whether speech was classified as pure speech and symbolic speech, political contributions and campaign expenditures, commercial speech and obscenity, or obscenity, and then the newest one, which is hate speech. So let's look at the differences. Commercial speech. So let's look at some of these differences. Pure speech means spoken words, whereas symbolic speech means any nonverbal action. So why is "I hate America" protected, but shouting fire in a crowded theater isn't protected as free speech? Because although generally the courts support freedom of speech, they will not allow words which endanger others. So you see, there are some limitations placed on our First Amendment rights. An example of symbolic speech would be wearing an armband to protest a war, and that would generally be protected as free speech. But if you want to burn the American flag, will that action be protected as free speech? You have read the result when you read the case in your textbook, Texas versus Johnson. You can see how many times these questions might come up in our society. A few years ago, a film director made a controversial film which depicted the Prophet Muhammad as an evil man. Should this film be allowed to be shown under the rationale of free speech? Well, if you answered yes to that question, what if the movie caused mass riots among Muslims and Christians? Would that then be more considered like shouting fire in a crowded theater? In 1976, the Supreme Court ruled that campaign expenditures were a form of constitutionally protected free speech. Then, just a few years ago, in 2010, the court said in the Citizens United versus Federal Election Commission case that government could not impose restrictions on corporations that it did not impose on individuals. Commercial speech includes businesses that want to advertise their products. Are those advertisements protected as free speech? Well, the court has said that deceptive advertisement will receive no protection as free speech. However, there's a difference between a deceptive ad, which is fraudulent and therefore not protected, and an ad which contains puffery, which is protected. For example, saying that a cereal is the breakfast of champions is only an exaggeration, and consumers should know that you will not win the Olympics because you eat a certain cereal. Just to review then, commercial speech isn't entirely, absolutely 100% free speech. There are limits for such things as false and deceptive advertising. The next type of free speech cases revolve around obscenity. Should sexually explicit materials be protected under free speech? What is obscene anyway? What's obscene to me may be perfectly okay to you. Isn't it more a question of age and gender, religious upbringing, morality, and such things? There's a famous quote from Supreme Court Justice Stewart, who said, "I can't define obscenity, but I know it when I see it." Unfortunately, that didn't give anyone much direction for deciding future cases. The Supreme Court has grappled with a clear definition of obscenity, and subsequent court cases have defined obscenity as patently offensive to local community standards, or lacks serious literary, artistic, political, or scientific value. If it is obscene, it will receive no First Amendment freedom of speech protection at all. But will the definition of obscenity change? That remains to be seen as the cases continue to come in. What about hate speech? Is it protected? Well, this is a relatively new area of constitutional law and has not been fully litigated yet. Hate speech is defined as a form of communication that expresses hatred for or violence against a specific minority group or other protected class of people. The upshot of what we've said so far is that free speech is not absolute. The courts may impose limitations on a person's right to express themselves. When deciding cases, courts generally use one of several balancing tests. Perhaps the easiest one to understand is the clear and present danger test. That is, courts will limit the right to free expression if it creates a clear and present danger, such as shouting fire in a crowded theater. Time and place restrictions relate to when and where free speech activities can take place. The government can limit free expression when there are security issues involved, such as guarding the White House. And as you read in the Snyder v. Phelps case, the court was asked to balance the rights of the mourners at a soldier's military funeral against protesters who were picketing outside the church. Although the courts sometimes approve of time and place restrictions on free expression, they are clear that the regulations must be content neutral. That is, for example, the city can't give Democrats a permit to hold a political rally, but refuse to give one to Republicans. When it comes to the separation of church and state, the cases divide into two different areas. The first cluster is around the Free Exercise Clause. Most Americans agree that people in this country should be allowed to practice their own religion in whatever way they choose. The second is around the Establishment of Religion Clause. The First Amendment states that Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. Does that free exercise of religion include Mormons marrying multiple wives, or Christian Scientists withholding medical treatments from their children, or cult members making human sacrifices? In the Yoder case, Amish and Mennonite parents didn't want to send their children to school beyond the 8th grade because they claimed that high school exposed children to ideas that threatened their religiously based lifestyle. When the court balanced the state's desire to have all students receive compulsory high school education with the Amish religious beliefs, the court held for the Amish. But the court reached the opposite result in Employment Division versus Smith and banned the use of hallucinogenic drugs by the Native Americans in their religious practice. You can read these two cases in your textbook to see why the court came to what might appear to be different conclusions. The Establishment Clause covers the extent to which the government can recognize and support religious groups. A couple of years ago, there was a controversial case in Texas when students wanted to write a Christian message on their football banners. They wanted to say, "If God is for us, who can be against us?" And you can click on the video to see the outcome of that case. Cases about the Establishment of Religion Clause have been decided in different ways over the years. For example, in the Van Orden case, the Supreme Court narrowly upheld a large stone monument inscribed with the Ten Commandments on Texas State Capitol grounds, while the same day they narrowly struck down a Ten Commandments display in a Kentucky courthouse. Another key component of the Constitution is the concept of due process. The right to due process is protected by both the Fifth and the 14th Amendment. So what's the difference between the two? Procedural due process is the requirement that the government follows certain procedures whenever they're trying to deprive people of life, liberty, and property. Substantive due process is the requirement that the government not deprive anyone of life, liberty, and property where the law being violated is found to be arbitrary or unreasonable. The last key concept to note in our discussion of constitutional law is equal protection. The Equal Protection Clause is found in the 14th Amendment. Nor shall any state deny to any person within its jurisdiction the equal protection of the law. As has been the case with most of the other rights discussed in this module, it is important to know that these rights are not absolute. The Supreme Court has never ruled that the government has to treat all people the same at all times and regardless of their circumstances. Rather, it has interpreted the 14th Amendment as prohibiting some, but not all, forms of differential treatment. The types of discrimination under the Equal Protection Clause that have raised issues are race, gender, sexual orientation, age, economics, and affirmative action. This presentation gave you a brief overview of the highlights of constitutional law. I encourage you now to do the exercises in the chapter and read thoroughly the cases so that you fully understand this controversial area of the law.